आज हम एक ऐसे फाइनेंशियल अग्रीमेंट की चीरफाड़ करेंगे जो गिरगिट की तरह रंग बदलता है। इमेजिन अ डील दैट स्टार्ट्स आउट लुकिंग लाइक अ पार्टनरशिप, जहां आप प्रॉफिट और लॉस दोनों शेयर करते हैं। पर देन अगर एक छोटी सी कंडीशन पूरी नहीं होती तो वो मैजिकली एक सिंपल लोन में बदल जाता है। और ये पूरा ट्रांसफॉर्मेशन, ये पूरा बदलाव सिर्फ एक 15 शब्दों की लाइन पर टिका था। वेलकम टू द डीप डाइव। आज हम सुप्रीम कोर्ट ऑफ इंडिया के एक लैंडमार्क केस बी.डी. भरूचा वर्सेस कमिश्नर ऑफ इनकम टैक्स 1967 की गहराइयों में उतर रहे हैं। हमारे सोर्सेज हैं इस केस की ओरिजिनल जजमेंट और एक्सपर्ट लीगल एनालिसिस, और हमारा मिशन है ये समझना कि कैसे ए सिंगल सेंटेंस इन अ कॉन्ट्रैक्ट, एक एस्केप हैच, पूरी डील की फाइनेंशियल एंड टैक्स आइडेंटिटी को बदल सकता है।
बिल्कुल। और ये केस हमें कैपिटल लॉस और रेवेन्यू लॉस के बीच के फंडामेंटल डिफरेंस को समझने में मदद करेगा। सुनने में ये टेक्निकल लगता है, बट इट्स एट द हार्ट ऑफ एवरी बिजनेस। हम देखेंगे कि कैसे एक डिफिजेंस क्लॉज, मतलब एक ऐसी शर्त जो किसी कॉन्ट्रैक्ट को नलीफाई या चेंज कर सकती है, इस पूरे मामले का टर्निंग पॉइंट बनी। ये एक मास्टर क्लास है इन रीडिंग द फाइन प्रिंट।
चलिए तो फिर कैरेक्टर से मिलते हैं। एक तरफ है बी.डी. भरूचा, जो एक फिल्म फाइनेंसियर हैं। एसेंशियली उनका बिजनेस ही फिल्म इंडस्ट्री में पैसा लगाना था।
राइट।
और दूसरी तरफ है ताराचंद पिक्चर्स, अ फिल्म डिस्ट्रीब्यूशन फर्म।
एग्जैक्टली। बात है 1952-53 की। भरूचा ने शबाब नाम की एक फिल्म को फाइनेंस करने के लिए ताराचंद पिक्चर्स को पैसे दिए।
वाओ।
और टोटल ऑफ 1 लाख रुपीस।
राइट।
उस जमाने में ये एक बहुत बड़ी रकम थी। लेकिन जैसा कि फिल्म इंडस्ट्री में अक्सर होता है, द मूवी डिडंट डू वेल। भरूचा को अ स्टैगरिंग लॉस ऑफ 80,759 रुपीस हुआ।
वाओ।
ऑन 31 दिसंबर 1955 उन्होंने इस रकम को अपनी बुक्स ऑफ अकाउंट्स में बैड डेट दिखाकर राइट ऑफ कर दिया।
1955 में 80,759 रुपीस। टुडे दैट वुड बी अ फॉर्चून। फिल्म फाइनेंसिंग तब भी कितना रिस्की बिजनेस था, और आज भी है।
और यहीं से लीगल बैटल शुरू होती है। भरूचा ने कहा कि ये नुकसान उनके फाइनेंसिंग बिजनेस का एक नॉर्मल पार्ट है, रूटीन लॉस। देयरफॉर अंडर द इनकम टैक्स एक्ट इसे एक रेवेन्यू लॉस माना जाना चाहिए, जिसे वो अपनी टैक्सेबल इनकम से डिडक्ट कर सकते हैं।
यस, ही क्लेम्ड इट एज अ डिडक्शन अंडर सेक्शन 10(2)(xi) ऑफ द इनकम टैक्स एक्ट। उनका आर्ग्यूमेंट सिंपल था, आई एम अ मनी लेंडर, आई लेंट मनी, इट बिकेम अ बैड डेट, दिस इज अ बिजनेस लॉस।
लेकिन एक मिनट, इनकम टैक्स ऑफिसर की बात में भी तो दम है। अगर आप किसी के साथ मुनाफा और नुकसान दोनों बांटने को तैयार हैं, तो आप असल में पार्टनर ही तो हुए। कोई भी नॉर्मल मनी लेंडर अपने बिजनेस का घाटा क्यों सहेगा? दिस ब्रेक्स द फंडामेंटल रूल ऑफ लेंडिंग, एंड दैट वाज प्रिसाइसली द इनकम टैक्स ऑफिसर्स आर्ग्यूमेंट। उन्होंने कहा, दिस इज नॉट अ लोन, दिस इज अ वेंचर इन द नेचर ऑफ अ ट्रेड। उनका पॉइंट था कि भरूचा ने पैसा एक बिजनेस इन्वेस्टमेंट के तौर पर लगाया था। Therefore, the loss was a capital loss, not a revenue loss. And you cannot deduct a capital loss from your regular business income.
अच्छा।
The appellate tribunal also agreed, calling it an investment of the capital for a return in the shape of share of profits.
तो क्या हम इसे ऐसे समझ सकते हैं, अगर मेरी एक बेकरी है और मेरा बनाया हुआ केक बिकने से पहले खराब हो जाए, तो वो एक रेवेन्यू लॉस है, बिजनेस चलाने का हिस्सा।
हाँ।
लेकिन अगर मैं अपना पूरा ओवन ही बेच दूं और मुझे घाटा हो, तो वो कैपिटल लॉस है।
Exactly. आपने बिल्कुल सही पकड़ा। The cake is your stock in trade, your inventory. The oven is your capital asset. The income tax department was arguing that for Bharucha, this 1 lakh rupees was like the oven, a capital investment, and Bharucha was arguing that it was like the cake, his stock in trade, the very thing his business dealt in.
Okay, so the entire case hinges on whether this transaction was an investment or a part of his normal business. और इसका जवाब अग्रीमेंट में छिपा होगा। मुझे यकीन है कि भरूचा के वकीलों के पास इनकम टैक्स ऑफिसर के आर्ग्यूमेंट का कोई जवाब होगा। एग्रीमेंट में जरूर कोई और पेच रहा होगा।
You're right. The devil, as always, was in the details. The income tax officer was focusing entirely on one clause, Clause 3 of the agreement. And on its own, Clause 3 looked very damning for Bharucha.
क्या था इस क्लॉज 3 में?
क्लॉज 3 में कहा गया था कि इस पैसे पर कोई इंटरेस्ट नहीं लगेगा। आई एम कोटिंग फ्रॉम द अग्रीमेंट। बट इन lieu of interest, it is agreed that the distributors will share with the financier profit and loss.
Oh.
And the ratio was also fixed. 2/3 for the financier, Bharucha, and 1/3 for the distributor.
Wow, no interest but a share in profit and loss. ये तो पार्टनरशिप की टेक्स्ट बुक डेफिनेशन लगती है. रिस्क एंड रिवॉर्ड दोनों शेयर हो रहे थे. If you only read this clause, the tax officer seems 100% correct.
Precisely, and that's what the High Court also believed. They looked at this profit and loss sharing mechanism and concluded that this cannot be a money lending transaction. No money lender shares the risk of the venture itself. But they missed the bigger picture. उन्होंने पूरे कॉन्ट्रैक्ट को एक सिंगल कॉम्पोजिट डॉक्यूमेंट की तरह नहीं पढ़ा.
तो वो बिगर पिक्चर क्या था? What was the catch?
The catch was Clause 7. The Supreme Court called it the crucial defeasance clause. As I mentioned, defeasance means to render something null and void. ये clause एक conditional trigger था, an escape hatch.
Okay, I'm listening. This sounds like the heart of the matter.
Clause 7 laid down a very specific condition. As noted in paragraph 4 of the judgment, the clause stated, and I quote, "In case the picture is not released in Bombay within 15 months from the date hereof, the distributors shall be bound to immediately return all the monies, together with interest thereon at 9% per annum."
Wait, let me get this straight. मतलब अगर फिल्म 15 महीने में बॉम्बे में रिलीज नहीं हुई तो प्रॉफिट लॉस शेयरिंग वाली बात खत्म.
Yes.
Partnership idea is out the window and this entire deal automatically converts into a standard loan with a 9% interest rate.
That is exactly what it means. It was a financial instrument with a built-in transformation switch. It was designed to change its character based on a future event.
अच्छा, तो मतलब क्लॉज 7 एक तरह का अंडू बटन था. अगर सब ठीक नहीं चला तो भरूचा कह सकते थे, ठीक है, पार्टनरशिप कैंसिल, अब तो मुझे मेरे पैसे 9% ब्याज के साथ वापस करो. That's a clever bit of legal engineering.
It is. And this isn't just a theoretical possibility. This is exactly what happened. The 15-month deadline was April 4th, 1954. The film was actually released on May 28th, 1954, over a month late.
So the condition was breached, the deadline was missed.
Yes. And what's fascinating here is the legal consequence of that breach. The moment the clock struck midnight on April 4th, 1954, Clause 7 was triggered automatically. There was no need for a new agreement, no negotiation. The contract itself dictated the transformation. Justice V. Ramaswamy, in his judgment, made this crystal clear. Quote, "It is the admitted position in the present case that the picture was not released by the distributors till the stipulated date, and Clause 7 of the agreement therefore came into operation."
So I'm a bit confused. The deal started as a venture. The loss happened because the venture failed. So how can the character of the loss change just because the deadline was missed? The loss is still connected to the original transaction, isn't it?
That's a brilliant question, and it gets to the core of the Supreme Court's reasoning. The court said you have to look at the legal relationship between the parties at the time the debt became irrecoverable.
Okay.
On and from April 4th, 1954, the relationship was no longer that of partners in a venture. It became a relationship of a creditor and a debtor. Justice Ramaswamy articulated this beautifully. I'll quote from the judgment again because it's so precise. The result, therefore, is that on and from April 4, 1954, there was a contract of loan between the parties in terms of Clause 7 of the agreement, and the principal amount became repayable from that day to the appellant with interest thereon at 9% per annum.
I see.
So after this date, any attempt by Bharucha to recover the money was an attempt to recover a loan, not an investment in a joint venture.
Okay, that makes sense now. So the nature of the transaction itself transformed, and because the nature of the transaction changed, the nature of the resulting loss also changed. The loss was now a bad debt from a loan, not a loss from a failed partnership.
You've nailed it. The loss was now incidental to his main business of financing and money lending. The Supreme Court then applied a key judicial test, stating in paragraph 4, losses in the running of the business cannot be said to be of capital. Since money lending was Bharucha's business and this transaction had legally become a loan, the loss was a revenue loss. It was a cost of running his business.
To make their case even stronger, did the court rely on any previous judgments or legal principles?
Yes, they did. If we connect this to the bigger picture, the court reached back to a very old and respected English precedent to solidify its logic. The case was Reed's Brewery Company Ltd v. Mail, an 1891 case.
1891, wow. That's foundational law. What was that case about?
It was about a brewery company that, as a part of its business, also acted as a banker or moneylender to its customers, the pubs and inns. They gave them loans to boost their own beer sales.
Right.
Naturally, some of these loans went bad. The tax authorities argued that these were investment losses, i.e. capital losses.
Sounds incredibly similar to Bharucha's situation. The brewery's main business was making beer, but lending was a part of it. Bharucha's business was lending, but he entered a venture-like deal.
But that parallel is very strong. And in that 1891 case, Judge Pollock B. drew a masterful distinction between capital invested and capital used in trade. The Supreme Court quoted him extensively. On capital invested, Judge Pollock said, quite simply, of course, if it be capital invested, then it comes within the express provision of the Income Tax Act that no deduction is to be made on that account. Clear and simple.
Right.
But then he explained why the brewery's money was not invested capital. And these words from 1891 became the bedrock of the Bharucha judgment in 1967. I'm quoting Judge Pollock again. What it is this. It is capital used by the appellants. Whether it be money lent in the course of their trade, it is used and it comes out of capital, but it is not an investment in the ordinary sense of the word.
I see. So the principle is, if you use money as a tool to run or grow your business, like a moneylender uses money to give loans, or the brewery used loans to sell more beer, it's capital used in trade.
Exactly.
It's part of your operations. The loss on that is a revenue loss. But if you park your money in a separate venture, hoping for a return, that's an investment. The loss there is a capital loss.
Precisely. And the Supreme Court applied this exact logic. They said that once Clause 7 was triggered on April 4, 1954, the money advanced by Bharucha stopped being an investment in the Shabab film venture. It became a loan made in the course of his regular financing business. It became his capital being used in his trade.
So with this principle established, the court just had to check if Bharucha's claim ticked all the boxes of the law.
Correct. The final step was a simple checklist against the conditions of Section 10(2)(11) of the Income Tax Act. 3 conditions needed to be met. First, the debt must be in respect of the business. Here, it was clearly in respect of Bharucha's financing business after the transformation. Second, the debt must be incidental to the business. This was also satisfied.
Okay.
And third, the debt must have become irrecoverable and been properly written off in the account books. Bharucha had done that on December 31st, 1955.
All 3 conditions met? It seems like an open and shut case once you read the contract as a whole.
It was. The Supreme Court overturned the decision of the Bombay High Court and ruled in favor of Bharucha. The final holding of the court was unequivocal. Quote, "It follows, therefore, that the appellant is entitled to claim the amount of 80,759 rupees as a bad debt, and the loss suffered by the appellant was not a loss of capital but a revenue loss. The appeal was allowed." A victory for reading the fine print.
This entire analysis makes one thing absolutely clear. The true character of a financial transaction isn't on the surface. It's hidden in the interplay of all its clauses and contingencies. Clause 3 made it look like a venture, but Clause 7, the diffusance clause, was the hidden trump card that turned it back into a loan.
This raises an important question for today. This case is from 1967. It established a fundamental principle about how contracts should be read holistically. But today we live in a world of complex startup funding, venture debt, convertible instruments, safe notes. The agreements are far more complex.
That's a great point. Today's deals have multiple what-if scenarios built in from day one.
Exactly. So the provocative thought for our listener is this. Are today's modern complex business agreements making the line between capital and revenue clearer? Or, with all their convertible features and multi-layered conditions, are they creating even more ambiguity and potential for litigation for tax purposes? This case from 1952 reminds us that every single clause, every condition, and every what-if scenario can have consequences worth lakhs or even crores of rupees. Something to think about.